Are you considering a career change? Perhaps you're interested in becoming a professional guardian. Here is some information about guardianship that may help you decide if you would like to pursue this rewarding and meaningful career. Hello, my name is Irene Roush, and as a professional guardian since 1982 and a guardianship instructor for the 40-hour course in Florida since 1989, I am frequently asked questions about what is it like to be a guardian? What do guardians do? How do you get started? How do you get cases? How much money do you make? I created this short video to answer some of those questions and to provide information that might help you decide if this is something you would like to pursue. In this video, I will cover what is a professional guardian, what are the qualifications to serve, how are guardians appointed, rights that can be delegated to the guardian, what are the guardian's responsibilities, how do guardians get cases, what is the role of the guardian, and importantly, how do guardians get paid? At the end of this video, there are additional resources that you can visit to get more information about guardians and guardianship. A professional guardian is an individual who has been delegated to exercise certain rights for a legally incapacitated person. These rights may pertain to the person and/or the property of the incapacitated person. The professional guardian is a person who has been appointed as guardian to 3 or more people who are not related to him or her. The professional guardian has a special obligation of duty and trust to this incapacitated person, and the professional guardian has the ability and the authority to make positive changes in this person's life. There are a few qualifications to serve as a guardian in Florida. An individual must be over the age of 18, not convicted of a felony, and have good credit with no bankruptcy in the past 5 years. A person who wants to serve as guardian for a family member only and not in a professional capacity must complete 8 hours of guardianship training. The qualifications to serve as a professional guardian are a bit more strenuous. An individual must complete a 40-hour guardianship training course, obtain a Level 1 background check that includes fingerprinting, must provide a current credit report, must pass the Florida Guardian Competency Exam, and must obtain a blanket fiduciary bond in an amount no less than $50,000. A professional guardian must register with the Office of Public and Professional Guardians annually and must complete 16 hours of continuing education every 2 years. Once an individual has been identified as needing assistance, someone must be willing to file a petition to determine capacity. The individual requiring assistance is referred to as the alleged incapacitated person, and the person who is signing the petition is referred to as the petitioner. Florida law requires that the petitioner be represented by an attorney when going through the incapacity proceeding. The attorney will prepare a petition to determine capacity and a petition for appointment of guardian. This attorney will remain throughout the longevity of the guardianship and is referred to as the attorney of record. The attorney will submit the 2 petitions to the court along with the appropriate filing fees. A probate judge will then appoint a 3-member examining committee to evaluate the alleged incapacitated person's capacity to care for his or her medical, social, and financial needs. The judge will also appoint an attorney to represent the alleged incapacitated person. The role of this attorney is to ensure that the alleged incapacitated person's rights are protected and only those rights that they are incapable of managing are removed and no more. In some instances, they may fight the guardianship proceeding. A hearing will be held about 30 days after the petitions are filed. At this hearing, both attorneys, the attorney of record and the court-appointed attorney, can call witnesses and present evidence regarding the capacity or the lack thereof of the alleged incapacitated person. After hearing all of the evidence, the judge will make a determination to do one of three things: dismiss the petition because it has not been proven by clear and convincing evidence that the alleged incapacitated person lacks capacity, or the judge may remove some of the individual's legal rights, or the judge may remove all of the person's legal rights. If any rights have been removed from the individual, the second part of the hearing will commence. Here, the attorney of record will present the proposed guardian's qualifications to serve. The court-appointed attorney will have an opportunity to question the proposed guardian in an effort to ensure that the guardian is capable of managing the alleged incapacitated person's problems. The judge will then make a determination if the guardian is appropriate. If so, the judge will delegate rights to the guardian to exercise for the incapacitated person. In Florida law, this individual is now referred to as the ward. Letters of guardianship, which list the rights that the guardian has been delegated, will be issued to the guardian. This is their authority to act. Rights that may be delegated to the guardian of the person are to determine the ward's living arrangements, to provide consent for medical options for the ward, to decide other social aspects for the ward, such as therapy, rehabilitation, educational options, vocational options, recreational activities, and clothing and personal needs. Rights that may be delegated to the guardian of the property include the right to enter into contracts on behalf of the ward, the right to file or defend lawsuits on behalf of the ward, the right to manage the ward's property, and the right to apply for government benefits. The legal responsibilities of the guardian of the person are to prepare and file an initial guardian plan within 60 days of their appointment. This will identify the ward's issues, problems, needs, and what the guardian plans to do to resolve those problems. The guardian must have the ward examined by a physician or psychiatrist within 90 days of the end of the reporting period to determine if they still require the services of a guardian. The guardian is also required to prepare and file an annual guardian plan within 90 days after the end of the reporting period. This plan will list all the various places that the ward may have resided during the past year and what medical treatment has been provided for him or her. It will also detail what the guardian plans to do in the coming year. The legal responsibilities of the guardian of the property are to marshal the ward's assets and file an initial inventory of all of the ward's assets within 60 days of the guardian's appointment. During the year, the guardian must obtain court approval for certain actions, such as selling assets, setting up trust, paying guardian or attorney fees, and paying funeral arrangements. At the end of the report year, the guardian must prepare and file an annual accounting. This will list all income that has been received, disbursements that were made, changes within the guardianship estate, such as sales or purchases, and a listing of all of the remaining assets as of the end of the reporting period. Guardians will get referrals for new cases from attorneys, hospital discharge planners, facility social workers, home health agencies, Department of Children and Families, and quite often from other guardians who may not be in a position to accept a new case at that time. The role of the guardian primarily is to be a surrogate decision maker for the ward, to do what the ward would have done if the ward was capable. The guardian also serves as a coordinator and monitor of services for the ward, as a financial manager if they are guardian of the property, and always as an advocate for the ward. And occasionally, the guardian becomes a miracle worker. Guardians must maintain an activity log, which is basically a description of everything that the guardian has done with or for the ward. The guardian will submit a petition via their attorney to the court requesting authorization to pay the guardian fees. The probate judge will review the activity log and the petition and determine if they are appropriate. If so, they will issue an order authorizing the guardian to pay the fees. The fees are paid out of the ward's account, or the guardian may submit the court order to another entity such as a trustee, custodian, guardian of the property, who may be responsible for paying the ward's bills. The guardian's fees are approved by the judge in each county, and they differ. There is no set scale of pay throughout the state. Fees for beginner professional guardians range from $35 an hour in some of the rural areas to about $120 an hour in some of the more suburban areas across the state. Fees are paid out of the ward's account or from funds managed by another fiduciary. If there are no funds to pay and the ward is indigent, guardians serve pro bono. Most guardians carry about a 30% pro bono caseload. You can obtain information on professional guardian registration, obtain a list of registered guardians throughout the state, find a link to the electronic fingerprinting, obtain a copy of the Standards of Good Practice for Professional Guardians, and find a link to Florida Guardianship Law, Florida Statutes, Chapter 744, at the Office of Public and Professional Guardians website, which is located under the Department of Elder Affairs. You can find information on the Florida Guardian Competency Exam by visiting the USF Center for Guardianship Evaluation, Assessment, and Measurement website. To find out information about continuing education and guardians around the state, visit the Florida State Guardianship Association website or the Guardian Association of Pinellas County website, or you can contact the president of the Suncoast Guardian Association, Larry Orendorf. If you are interested in registering for a 40-hour guardianship course, please visit my website, www.guardiantraining.com. I offer the class 4 times a year in Clearwater, Florida. The course is offered on 4 Saturdays, 8 a.m. to 6:30 p.m. The registration fee of $450 includes the 4 class days, 3 books, a CD with guardianship practice forms, refreshments at break time, and lunch each class day. I hope you have found this video helpful, and thank you for viewing.